Okay, hi everyone, it's Grant Abbott speaking. Welcome to this session on, although I've talked about it, BDBNs, SMSFs, Testamentary Trust and Reversionary Pensions plus. We're going to be looking at SMSF Death Benefits Trust. We'll also, from that perspective, what I'm going to be looking at is a few issues or case study and looking at a lot of these issues within a case study. I think it's just preferable for us when we go through this process to consider how this sort of stuff at a high level works rather than just simply go through the various rules. So let's get on with it. With the case study that we're going to look at here, we've got John Smith, who's a 60-year-old doctor. We've done this case study before, but it's a good one to reprise and bring in and have a look at it in the context of these death benefits. So what we're doing is we're presenting and preparing an estate plan for John. So as we go through, we'll look at various issues. So he's a 60-year-old doctor. He's got his own practice. And he's a locum at 2 local hospitals. He operates his business via discretionary trust. So that's not a bad one. Gives a little bit of asset protection there as well. I'd like to know who the trustees are, etc. John and Sally are married. They've got 3 investment properties worth a total $2.2 million with $300,000 in debt. So effectively, they'd be very cash flow positive. Probably the last thing he wants in terms of income coming through. An SMSF, which we're going to look at, with $1.4 million in his lump sum account and $1 million in Sally's account with John and Sally as trustees. They live in a $2 million property in Manly, New South Wales with a disabled daughter, and the house is owned with no debt. The property is in his own name. John and Sally have 3 children. We've got Max, who's 35, who's a stockbroker. And according to John, chip off the old block. He lives in Sydney with his wife, Samantha, and 2 children, Kathy and Janine, who are both bloodline of Max and also bloodline of both John and also Sally, their grandparents. Max has a sister. John and Sally have a daughter, Sarah, who's 32-year-old doctor working in country New South Wales. Is very successful. And is estranged from her father, but not necessarily a mother. We've also got Jody, who is 21 and John and Sally's only child together, who's disabled and still living at home. So when we go through, we'll have a look at that a little bit later on. John completed a will with his family solicitor. In fact, sorry, I've just got this. Max and Sarah from a former marriage. Sally's the second marriage. The only one they've had there is obviously Jody. John completed a will with his family solicitor in 2010, giving all of his estate to his former wife and a BDBN directing the trustee of the fund to transfer all of his superannuation to his estate. So obviously we've got some problems there in terms of the original BDBN and more importantly the will now that he's effectively been divorced, has now a new relationship or new marriage with Sally. The executor of the estate is his wife. So what we want to do is we want to start to look at those core ones, and it doesn't matter whether it's a smaller version you're looking at for your clients, but essentially this is a sort of case study, circumstances, events that you're going to have for all your clients. There's going to be some in the family you want to bring in, some out. There might be a disabled child, second marriages, bloodline issues. So we want to go through all of those. So I've chosen a case study that we'll probably look at it on many occasions. So the first thing is that I see is overall from a succession asset protection and estate planning piece, although we are going to drill down into the estate planning, is that if you have a look at John and to a lesser extent Sally, much the same as us as professional advisors. John's a doctor, and likewise, many of our professionals and clients have got investment properties and also their homes in their own name because of tax purposes. There's obviously the 4 big ones that we have to be watching out for. Each one of these, or a multitude of them, can destroy a family's wealth. Now, it's great for John to effectively have a $2 million home. Superannuation is to a lesser extent protected, those investment properties, but if there's a negligence claim and his PI doesn't cover it, then effectively we're going to go down the track and essentially find out that most of his assets are at risk, which is obviously extremely concerning. I looked at a client only yesterday, and they had 12 properties in their own name, which is great, but there's a huge risk there. If someone falls over on those properties, becomes incapacitated, permanently disabled, then obviously there's an action against the owners of the properties. Whether life or whether insurance or landlord insurance covers it, we tend to know that insurance companies generally say no quite a bit before you can make a claim. So litigation is obviously a huge issue for someone, a professional like that, and for all of us, or everyone on the call, it's the same sort of thing. So the strategies we're going to be looking at today are also important for our own personal perspective. Bankruptcy starts with the creditor's petition. Obviously, we haven't got that issue here with John, unless, of course, there's a negligence claim, or you never know what the medical boards could take action against, which is important. Family law is obviously been divorced before. We'd have to find out where Sally is in the whole scheme of things, and whether he wants to obviously be looking after Max and Sarah, although he's estranged from Sarah, and of course Jodie as well. Family provisions claims, well, if there's a good chance, in fact, Sarah, who's estranged from her father and obviously doesn't like Sally, there's a good chance that Sarah's going to make a family provisions claim. So if something happens to John and he's got the home in his own name and the investment properties, then irrespective of what we put into the estate, a family provisions claim like this on such a reasonable size estate would probably take about 4 or 5 years to settle, and more importantly, would probably cost upward of $200,000 to $250,000 in legal fees. Quite often that estate planning process and family provisions is extremely concerning. We've also got, if this is in New South Wales, we've also got the notional estate, which we've got to be extremely careful. And there's also a potential 3-year clawback if we've gone through the process of putting assets into, for example, a trust with the purpose of diminishing our estate, which is not a bad thing, but that only happens in New South Wales. So they're well and truly advised for everyone else. So we want to start, the first thing is, in my mind, is that the structure that's been set up for John is obviously one of great concern. I'd want to do a bit more of a deep dive on it and restructure him completely. But what we're doing now is we're going to focus in on the BDBNs, reversionary pensions. We're going to be having a look at testamentary trusts, and also the SMSF Will. So what I want to do is take that and have a look at it. Just to go back to the case study, we've got John's got 1.4 million on a lump sum account and 1 million in Sally's account. He's only 60 years of age, and he's a locum of 2 doctors. Locum at 2 hospitals. So we're going to get down there. The key, again, for those of you who've been following me, always the moat and the castle. So we've got the SMSF discretionary trust, all those properties are the castle, and at the moment we've got no moat around it, so they're not protected. So they're really open to the ravages of what's going on. Probably pretty important in the light of what's going on in Afghanistan at the moment, to show you the problem. If you don't have proper procedure and planning, things can spiral out of control very quickly. If we go through and have a look here, when we go down this family wealth protection route, and I think it's absolutely crucial, and we're going to dive into that estate planning very shortly, there's this, the hierarchy of competence, or the 4 levels of competence and confidence for that matter. Unconscious incompetence is that really you don't know what you don't know. For example, many accountants will simply do a BDBN for the client, not knowing whether it actually works or not, or can be contested. Simply complete a piece of paper, and that's red line danger there to start off with. Second one is we get up to a stage of conscious incompetence. Many of you who did our 3-day session for the SMSF Advisor Accreditation course, you would have got that in the first probably half day or a day. That there was a lot on there around, we knew some things, but we didn't know in detail. So we felt consciously incompetent. Next one, of course, is the conscious competence. So that's where many of you have done the course. You've got your accreditation, certifications coming out very shortly from Pepper once we launch formally in September or early October. And so that way you can build a right analysis around a client's set of circumstances. Unconscious competence, which is we know our stuff extremely well. So we can actually, instead of having a deep dive, we've got a good intuition around where things are going. And what I want to do is use my intuition and my analysis and provide them to you. But fair enough to say that that red line there is danger, because effectively if we stuff up, then we're going to end up in a family provisions claim. And for those of you who've seen me talk about the Miller and Taylor case, which was took over 5 years and more than $500,000 legal fees and a $600,000 case, effectively that's like the be all and end all. So we've just got to be really keeping our clients away from that. In fact, if you heard me, I prefer to keep clients away from estate at all. I'd love clients to, if they're going to pass away with no assets whatsoever. So that's our 4 levels of competence. So let's just have a look at each step. I want to have a look at the SMSF. So importantly from that perspective, step 1. So I'm going to give you steps for each of these. The slides will be out later on today, as will this video. And also I'll send out the 2 deeds that I'm about to review for you. Plus also an article I did on why you should not do BDBNs and SMSF Will is better. So let's just go down through the analysis. So we can't do anything until we check the deed. So the first one I'm going to look at here is I've got a deed here. I think I've got it here. So let me just have a look. Did I get it here or it's up here? Okay, so I think I've got it here. Let me just have a look. I'll just pull this down and we'll have a look at for our deeds. Trustees, trust binder, superfix, super tax, statutory SMSF establishment, that's our one. And then, okay, so this is a sample for us, but I'll have a look at our document here, and then I'm going to pull down one for you to have a look at. So this is the light year docs deed that I've drafted up. Let's go through and have a look here. So Rule 6.4 provides for SMSF death benefits and binding death benefit directions. So we'll go and have a look through there. Subject to the superannuation laws of the fund retaining its complying status, where a member of the fund dies, the following death benefits may become payable by the trustee of the fund. A member of a fund may make a SMSF will or binding death benefit nomination in the form or manner as prescribed under the definitions of those terms. So that means we need to go and have a look at the definitions, which we will shortly, which, if accepted by the trustee, will legally bind current and future trustees on how a deceased member's superannuation benefits are to be paid. This may include the payment of a lump sum to a dependent or to the member's legal personal representative, the payment of an income stream to dependents of the members, whether singly, jointly, as a group, limiting any payments to a deceased member's bloodline or lineage, whether directly or indirectly through the deceased member's legal estate, whether an existing order of reversionary pension, if the reversionary beneficiary is alive, takes precedence over any SMSF will or binding death benefit nomination. This is important for all of you. The importance of a superannuation professional to advise upon, help manage and administer the deceased member's estate. Remember, this is a contract that you also are a party to. Any other thing or matter agreed between the trustee and the member to form part of the member's binding SMSF will or binding death benefit nomination. So you can see there, we've actually built within the rules of the fund, because those rules of the fund are enshrined and also have the full import of the Superannuation Industry Supervision Act. So we've got this flexibility built within the deed, really for you guys to create an SMSF will or a binding death benefit nomination. My preference is always an SMSF will, and you can create that. Now, we've got a whole lot of other rules there about what happens if there's no will, etc. If we have a look here, this is a pretty important one. Where a member has an auto reversionary income stream or pension with an auto reversion transferable to a dependent of the member, created pursuant to the rules of the pension income stream or alternately by SMSF Will, a binding nomination or non-binding set of instructions, then subject to the super laws and the terms and conditions of the income stream, the trustee shall transfer the deceased member's income stream or pension to the order of reversionary beneficiary as soon as practicable after the member's death. So this is the process. So when a person dies, if there's auto reversionary, it automatically goes to the next person. So this is the process, the systems, the tools, the resources that you need to create an action plan for death. It's actually all there for you. You don't need to go and find your right way out of it. It's built within the rules of the fund and hence the legislation. Upon this auto reversionary event, amounts standing to the credit of the deceased member's auto reversionary pension are not to be considered as members' super benefits, but the superannuation benefits of the auto reversionary beneficiary. Subject to the terms and conditions of an auto reversionary income stream or pension, the super laws at that time, the auto reversionary pension may be transferred to another auto reversionary beneficiary upon the death of the first or latter. So that way we have cascading ones. So in this instance, we're going to be looking, and I will go through, but John is age 60. You'll see a little bit later in the steps, he works as a locum for two hospitals. Because he's turned age 60, and if he gives up one of those locums, even if it's just for a short period of time, his current balance in his superannuation fund, the $1.4 million, he's deemed to be retired. Hence, he can actually commence a pension so that we could take the $1.4 million from John's account, and then we can put it over into creating a pension for him. So the pension, we'll see a little bit later on, can go from John to Sally, his wife, and then down to Jody, their daughter. Or alternatively, it can just go from John to Jody, their daughter, their disabled daughter, depending on what is going to happen with Sally in that regard. Bearing in mind that Sally, my second spouse, gets on well with Max, but doesn't get on well with Sarah. So we've got to keep it well away. Whatever we do has to keep away from the estate. So we don't want to just transfer a lump sum if something happened to him into the estate, because we know it's going to be challenged. Many of us aren't really aware of the process of what happens versus SMSF versus what happens into an estate. So let's say, for example, we've got the $1.4 million and there's no family provisions challenge that we're aware of. So that $1.4 million, and we want to pay it out to Sally. So it goes over to the estate, and then in the will we've got in there that that $1.4 million is to go into a super proceeds trust. Well, what happens in that process, and Tony, if you listen to Tony before he comes on, and he's gone through the process, but essentially client dies, death certificate, then there's a bit of passing, then there has to be an advertisement into the Supreme Court to let everyone know that John Smith has died. Does anyone want to contest the will or make a family provisions claim? So after 14 days, generally then there's probate. We go to probate. We have to go to probate if the superannuation to go to super proceeds trust, which is a testamentary trust built out of the will. Then we have to, well, if it's not part of the will, you will have to then go and build the super proceeds trust, which generally the best one to do is use a leading member discretionary trust for that. Now, once it gets there, then we have to wait for a period of time, which can be 6 months, 12 months, depending on the jurisdiction. I'm pretty sure in New South Wales, I'd have to go in our strategy centre to have a look. I haven't got all that knowledge in my head, but I think it's 12 months for a family provisions claim before we can actually start to pay that money out. Whereas for superannuation, as soon as we get the death certificate, that membership ceases, and then we can start to make the payout. If it's an auto reversionary pension, so it goes from John to Sally, well, it happens straight away. We've just seen that in D. As soon as John dies, it's no longer his pension. It transfers directly over to Sally, which is pretty crucial. So we've got another one there. You'll really love this one, the living will, but that's not for this time. That's for a little bit later on. So all we need to do is just to expand on that. We need to start looking at some of the definitions, because the definitions give us what's there. And so once we've got this deed and we really understand the deed, we should be able to make a headway. It gives us our systems processes. So an auto reversionary income stream, remember we saw that before, it just jumps from one person to the next and the next, means an income stream or pension where a person, including a dependent, the auto reversionary beneficiary is included in the income stream or pension documentation as the recipient, if alive, of the member's income stream or pension upon the death of the income stream or pension member or beneficiary. The pension or income stream may revert jointly to 2 or more qualified persons or dependents in such proportions as the pension or income streams allow, and may continue to revert on the death of any auto reversionary pension. So remember, for example, we could do a pension. For example, we could go from John, and consider this, directly down to his 2 grandchildren, provided they're financially dependent upon him at that stage. Then we're able to pay out a pension to it. So it goes to John, and then the next recipients are his 2 grandchildren. I'm not saying you do that. I'm just showing that this is possible, and this is what's allowed under the deed, so that they would then hold the income stream jointly. They will receive the income stream jointly, but then if one dies, then the other one receives that income stream. Now, many of you are probably thinking, well, hold on, you can't pay an income stream to a child. Well, you can. You can pay it to children who are minors. That's exactly what it's for, but you can't pay to, for example, an adult child. These, the 2 ones, Katie and all that, are grandchildren, so we don't have to worry about that. That child exclusion, the ability to only pay a pension up to age 25 if they're financially dependent, doesn't apply to grandchildren, brothers, nieces, nephews, etc. Provided, of course, they're financially dependent at death. So we've had a look at the auto reversionary pension, which is a tool in our arsenal. So we know what the law is. We know the process, the system to build that. Julie, you had a question there. If you've got an existing auto reversionary pension, if you upgrade, make sure you upgrade the deed to our deed, and then you find that built within our pension capability is the ability to add a reversion onto that existing pension. And you'll find that in the system, if you type in reversionary, then you'll find that there's an addition of a reversionary pension or reversionary conditions to an existing pension. So that's in our system. So binding death benefit nomination, look, I'm not a big fan, but I put it in there anyway because a lot of people will do, and we will have that facility available. But again, the preference is for the SMSF Will, which has 6 terms and conditions as part of the contract between the member and also the trustee of the fund, which includes a contract for you to act as that SMSF administrator in the event of the death, which is absolutely crucial. A BDBN isn't so detailed, so contractually aware, so specific. So it's more about percentages or dollars. But BDBN includes any document accepted by the trustee of the fund dealing with the transfer of members' benefits, including any reserve benefits. Binding death benefit nomination is binding as upon the trustee, both past, present, future. It must be signed by 1 or more witnesses unless the trustee agrees otherwise. So you can sign it just with 1 witness, which is fine. Trustee accepts it, it's off and running because it's built into the deed. SIS Regulation 617A, which talks about the need to do 2 witnesses, plus also have it lapsing every 3 years. The danger about that position is that the Commission's already said has Donovan and Donovan that case that Regulation 617A doesn't apply to self-managed super funds. So it's virtually redundant. It's mainly for public offer and retail funds, as you'll see in the article that I'll put out a little bit later on. And again, I hasten to add, you should probably come and look at this a couple of times, look at the deeds, look at the steps that I've gone through, and then start to think of how that applies to yourself, and then apply it obviously to your clients. So again, if you have a look at the Commissioner's ruling, for those who are on the SPEPA course, you'll find that in the estate planning resource section. But the ATO ruling on binding death benefit nominations, which SMSF Will is a set of binding death benefit directions, really flows out of what is allowed under the deed. Now, because we've put it under the deed, you only need 1 witness sign off, then that's all you need. If we just go down a little bit further and have a look at death benefit, includes subject, and this is important, subject to the super laws of the fund retaining its complying status, a payment, including by way of an in specie asset transfer The problem is if your deed only allows a payment, then obviously you can't transfer an asset out because there has to be a payment. What you'd have to do is do a promissory note, then the promissory note is then used to acquire that asset unless it's specifically included. Of a super lump sum or superannuation income stream to a dependent, the legal estate of the deceased member of the fund, or to any other person, however, excludes any ongoing pension or income stream payment to a reversionary, which makes sense. Dependent is the big one. So again, dependent includes, wherever you see this, an inclusive definition means there's an ordinary meaning of the term dependent, which is generally financial dependent, but includes, subject to the super laws and the fund retaining its status, a spouse of or a child of the member of the fund, or a person in an interdependent relationship with a member of the fund, or any financial dependent of a member of the fund, irrespective of age, and any other person the trustee's opinion is a dependent. So it includes obviously financial dependence, which is crucial. And for those who haven't seen our family allowance agreements, they're absolutely crucial, but that's going to be the subject of another talk. If we then go down and have a look at SMSF wills, so I've got a living will, which we won't talk about. That's for incapacity. That's absolutely crucial. Monitoring incapacity benefits out of a superannuation fund, you must do them by an SMSF living will. But a member SMSF will includes a formal or informal set of binding directions made under these rules by a member and agreed to by the trustee in dealing with their SMSF legal estate to benefit a member's dependents or legal estate in the event of their death. So if you have a look with the SMSF will, you can go and have a quick look. I'll see if I've got one here. So I'll just go in quickly, have a look in the website. And I've had a look at the latest site, which will be up hopefully in early October. It looks very, very special. So having to use Firefox and all that, it's not going to be an issue. You're going to be absolutely blown away with what it can do to start off with, let alone what's coming down the track. So if I just show you an SMSF will, just so you can have a look. LYD will, SMSF will, there we go. I'll just go there. I can relaunch it, but I'm just going to download it. And I'll put it up into Open with Nitro. And there we go. So that's an SMSF will. So you can see there, you can create that on the system. I've just gone to the end product so you can have a look. There's a product disclosure statement, which is really just going through all the ins and outs of benefits and payment of death benefits and what you can do, who's the financial dependent, regulatory guidelines, lump sums versus income streams, etc., and taxation. And then we go down to the application by John Smith to the trustee acceptor SMSF will. So you can see here's the 6 elements. And if you haven't got these in BDBNs, certainly there's a weakness there. And I'm sure lawyers like Dan Butler and all that have probably got all these in pat for their BDBNs as opposed to others. Revocation of earlier BDBNs and SMSF wills, obviously that makes sense. I mean, if you don't revoke it, which one actually stands as being the correct one? You'll see also one of the big elements too is that the first thing the family provisions lawyers will start doing very shortly is looking at BDBNs and obviously making challenges to them. We need to work out whether a reversionary pension takes precedence. I would always put it as precedence. The main thing is for a reversionary pension, as we noted, once it stops there, so if it goes from John to Sally or John to Jody, because Jody's obviously as a disabled child, she's treated basically as the ability to receive a pension for her life. So there's conditions around that in Regulation 621. So it could go from John to Sally or John to Jody. And if that's the case, then remember it goes from one to another. So therefore that can't be caught up in a family provisions challenge because it's an existing income stream. So the reversionary pensions are the best not to get caught up within an estate. But we want to make sure it takes precedence. Otherwise, if you do a binding death benefit nomination, there's a reversionary. It has been argued that potentially the binding death benefit nomination overtakes a reversion. So you'd have to cut it out, which then obviously creates a problem. Appointment of a replacement trustee and member. So what will happen is the executor on the death of John will come in and be the replacement director potentially, if we've set it up like that, unless it's a leading member SMSF. Death benefit payments. So we've got there death benefit payments. There you go, I've done this before. I'll go through this. I want to just cover a couple of issues that are important here. So we've got the death benefit payable. All my super interest less the property going to James. So this was an earlier case, so it'll be Max. But this benefit may be paid as an income stream. So the 1.4 million, if it goes to Sally, if allowed under the super laws, which is the case, it can go, or transferred directly to the designated beneficiary, so it can go out to Sally, or any trust, company, person, or other entity that the beneficiary directs. So, for example, Sally could say, oh, I've got this discretionary trust over here. I want you to take that money and settle it into that, or pay it into that trust, which is okay. Including a transfer to the deceased member's estate. Now, we don't want to do that because remember, this is coming directly out of the SMSF. It's not necessarily caught as part of a family provisions claim. Although this is in New South Wales, we just have to worry about the notional estate issue. So we want to keep it out of that family provisions claim. The other one is, and that's only for New South Wales, everywhere else you don't have to worry about that. At the direction of the beneficiary or a leading member, the trustee may create SMSF Death Benefits Trust, which is a special purpose testamentary trust for superannuation. We saw one, and these are different sections of the Income Tax Act that says, okay, I'm going to put it over to the estate and then set up a superannuation proceeds trust. So that's allowed under the law. The problem about that is if I put it over to the estate, what happens? Effectively, it's going to get caught under a family provisions claim. Whereas if it stays within the fund and then effectively the trustee, with your advice, obviously, that's why you want to be the contracted advisor to the SMSF estate, will then create the trust and then put the proceeds for Sally directly into that trust, and will be treated as a testamentary trust. So that obviously there's over that, if there's any minor children, they'll just pay tax at their adult marginal tax rates. Now for Jodie, it's a bit different because she's already a disabled child. So you can have a look at that. If there's no beneficiary alive, and then if there's no beneficiary alive, then we work out what happens there, and so on and so forth. And then we've got succeeding beneficiaries, and there you go, nomination and professional review. There you go, Sebastian Mazza and stuff like that. So that's essentially where we're going with that SMSF will. As you can see, it's a lot stronger comparatively to a BDBN. But I think I've got here, if we have a look, so this is a superannuation warehouse. I just want to go through here. So to download the deed, okay, I've already downloaded it, so that's where it is. It's actually sitting in my Word documents. Okay, so here you go. So this is a trust deed from superannuation warehouse. And I don't know why they use this, because effectively they can use our deed because they're a strategist member. But anyway, let's have a look at the member benefits. I'm going to go up to the definitional sections, and it's really confusing. So, and you're like me, you just read it and work out, well, do I really understand it? So binding death benefit notice means a notice given by a member or beneficiary to the trustee in accordance with Regulation 617A. So that's the first problem. Is that, are they saying, if you understand the circularity of the argument, is the Commissioner and the cases have said 617A of the SIS regulations do not and have never applied to self-managed. Whereas here, they're trying to tack on 617A. So are they saying it has to have two witnesses and also be lapsing after 3 years? Are they importing that regulation in here for the binding death benefit notice? What does it mean? Simply, you can't have a binding death benefit notice because regulation 617A doesn't apply. Either way, it would, if you did a binding death benefit notice under this deed, definitely I'd be challenging it straight away, because it'd end up in court, because I'm not sure exactly what the resolution there. We've got this other one. Death benefit agreement means all of that part of an agreement describing the trustee's obligation concerning the payment of benefits on a member's death, which directs the trustee to pay the benefits to a person, has been executed by the trustee or member, has not later been terminated. So this death benefit agreement and binding death benefit notice are two completely different things because they've got different definitions. So I don't understand how they work completely. So we're just going to have to go down and find out. There must be some reasoning for it. So let's go down and have a look at what death benefits are required from here. So there's benefits, payments, pension mode. I won't have time to go into, obviously, the pension mode. Where is it? There we go. Members' benefits upon death. Okay, so now we've got something else. We've got a death benefit notice. We've got a death benefit agreement. Now we've got something else. So we've got, obviously, when we do this D, we've got the death benefit agreement nominations will be as follows. So that's obviously to the spouses. So that death benefit agreement that we looked in before pops into here for some reason. So it actually gets hard-coded into the deed, which isn't a bad thing, but again, I'd probably challenge it because it doesn't, there's no process or system in that terminology death benefit agreement as to what is properly executed. It looks to me as that just simply by hard coding it into the deed, effectively it's supposed to be law, and I would challenge that. That means because there's no one who's actually signed it. Where there is no valid nomination of death benefit, so now we're actually going back to the other one, that remember that nomination benefit, the trustees may pay the member balance to dependents or legal person represented in any proportions that the trustee deems appropriate. So it's flexible, it's true. This trustee provides for the use of a pension reversionary benefits upon the death of a member. The trustee has decided if an income stream or lump sum will be paid on the death of a deceased member. If after the death of a member or beneficiary, not all death benefits have been paid or applied in accordance with a death benefit agreement or a binding death benefit notice, then the trustee, and then we go through a process that it's almost like being intested there. So it's funny there that in this, what happens to members' benefits on death, it sort of talks about this death benefit agreement nomination, but it doesn't talk about the validity or how to accept or that the trustee is bound to pay that binding death benefit notice. And again, remember we said that we think that, you know, because it talked about 617A, it may not apply. So you can see here, compared to the process and systems that are laid down in that Lightyear Docs clause, this one is very loosey-goosey, and I would say is probably completely irrelevant personally. So I wouldn't be relying on any of these, which is fairly important. We've just got a couple of questions, and then we'll get into the other one. Okay, saw that one. So Owen, thank you very much for that. The federal government's just passed the Treasury Laws Amendment Measures Bill to facilitate the electronic execution of documents under Section 127. So Section 127 is any corporate document. So that's fantastic. So we can go digital signing. I do know that they are working, and there's been a group that's looking at facilitating this whole process across all states. But we'll wait and see. I think the pushback there is many lawyers would prefer clients to come into their office for some reason and sign the documents rather than that. But obviously with lockdown, it's a bit tough. So Owen, question, therefore, can things like SIP that requires a witness can be electronically signed, as in the essence, the IP thread proves it was witnessed? If we have a look at that, we're probably in a position, certainly in the corporations. So anything to do with federal government, absolutely. Probably could, I would say that by its very nature, the SIS Act is obviously included potentially in there if you've got a corporate trustee. But when we have membership, I would still want to go down the track of getting the member to sign and remember, work out how many witnesses. For our SMSF Will, if I have a look here, let me have a look at the SMSF Will, how many people have to sign. So I think I've got one, yeah, we've got 2 witnesses. So that's just the way that we do things, which are important. So Daisy, clear docs have BDBN lapsing and BDB agreement non-lapsing. Okay, so that's okay. But again, Daisy, I think you'd probably, I haven't got time to go into it. You need to go into the deed, read the process in the deed, have a look at the BDBN, look at what it covers and what you can cover. Because if it's just simply a percentage of benefits or whatever without being able to nominate details, then it's obviously very weak. Remember, we want to be in a position from our perspective, if I have a look at here, we want to be in a position that when we're down here, that we are consciously competent enough to be able to read a deed, understand the limitations of, for example, a clear docs deed, or definitely that superannuation warehouse deed, and work out whether we want to go down that track, or alternatively upgrade the deed and do an SMSF will. I mean, if it was my personal, and again, Daisy, I'll put it to you, which would you prefer? Would you like to have a BDBN that might be challenged, or would you rather have a strong, 6-step SMSF will? And again, you can see there in SMSF will, you can't use our SMSF will documents for the superannuation warehouse deed, nor the clear docs one, because obviously they don't countenance such detail. But again, everything, you just have to make a decision on where you are. Let's have a look. I've got Ken. SMSF will is the area that would allow real estate property in SMSF to be retained in the fund for the spouse under a pension. Absolutely. So we can go down that track and say that this property is to stay in to fund that. So that's good. Okay, exactly, Daisy. You do it for yourself. Let's go in and have a look a bit further. So I've taken in and I want to go through. So what we've got there is check the deed. So make sure you have a look at a good deed. And again, I'd probably put it to you and all your clients. There's two things that, for those who've done the SMSF course, you know where I'm going to go with this. They've all got to be on the same deed. All discretionary trusts have to be on the same deed. All SMSFs have to be on the same deed, and you have to have that successor director solution in play. So they're the three core ones just to get your foundation right. Once you do that, then that enables you to do an SMSF will or do whatever structures or transactions we want. So, but that doesn't mean, from your perspective, from a conscious competence, I'm showing you my solution here. It's still worthwhile to go and have a look at deeds and start to pull apart deeds and go and see, pull out 2 or 3 deeds and work out, well, is it strong? Is it secure? Does it do what I say? And that's not only just SMSFs, it also includes discretionary trusts. So check the BDBN to see whether it's valid or can be contested. Certainly in terms of that superannuation warehouse deed, absolutely, I'd be challenging it because look, I don't know about you guys, but it's damn well confusing for me. And if it's confusing for me, then it's going to be confusing for a judge. So I know that there's a good chance it'll be knocked down. In his BDBN, remember, it's being sent to the estate. And we already know we're going to have to fix up the estate and the will. So we're going to have to go down through the will because his former wife is the executor and also the beneficiary. So we need to knock that on the head. So why would we be sending super, and particularly if we know that Sarah, the daughter, hates Sally, but if we want to look after Sally and Jody, the daughter, we don't want to send it to the estate because we know that effectively Sarah's going to challenge it. That means there's at least probably 6 months to 18 months before we're going to get any resolution, and potentially up to 3 to 4 years with an estate this size. But look, if you went to a no-win, no-fee lawyer, they would love this because there's some good fees out of it. So we want to devise an alternative strategy. The strategy there is, if we have a look at this, as I said, retired John by ending one locum. So he's now retired, and effectively his $1.4 million becomes unpreserved, restricted. We commence a pension. So we can commence it to go to Sally, and then we can go to Jody if we want, or alternatively, we can just go to Jody if we want to do that. Now, the benefit of going to Jody is twofold. First off is the monies that would go to Jody. She'd get the pension. from her perspective, because it was originally tax-free to John, it would be tax-free to Jody as well. And obviously the income in there is also tax-free. So it's a really good strategy there in order to provide that tax-free income. Just got to be careful if you want to set up a special disability trust and watch out for the assets test to be an issue, because here we're putting $1.4 million in. So she's obviously not going to get Social Security for that one, but it looks as though she's pretty well looked after. So the choice is either go Sally and then Jody, or just go to Jody, either one. Remember, Sally's going to be the guardian anyway, so it's probably not a bad idea to do that one. Step 6, set up a SMSF corporate trustee with John as the director. So I'd go in, change the deed over, John as the director. I'd get rid of, even though Sally's a member, I'd probably even make Jody a member potentially of the deed. But what I would do is I would get rid of Sally. I can be a member, but she hands over her trusteeship or directorship to John through an EPLA. So remember, we've been through this before. Members don't have to be directors of a corporate trustee if there's an EPO in play. We can bring in Max. Again, it's going to depend on if we want to have that line of succession. A lot of it's going to depend on how well Max gets on with Sally, because it's quite easy, for example, to have John, Sally, Jody, Max, and Max's 2 children. That whole bloodline are just sitting in there, although it is a blended family. But again, we have to be trusting Max on that one. So it may not be the best idea to bring Max in. But again, we don't know until you actually put it to the client. Okay, so let's look at the family home. So this is a little bit problematical. So what we've got there is got the family home. It's in John's name. So he obviously got that out of the original divorce, never split it jointly with Sally. So if John wants her to live in it, then essentially what we do is Sally would have a life interest. And then after she has that life interest, we might give that life interest to Jody, although that might not be appropriate while Sally's not alive. So with that life interest, I did a question on this the other day. For those of you who saw the session on Tuesday, we looked in detail at what a life interest is. It's a trust that's basically established out of the will. Now, the only thing that I worry about there, again, is the family provisions. So we can create testamentary trust. Remember, I talked about the super proceeds trust. I can put this into a life interest trust, or I can take some of the investment properties I'll look at a little bit later and set up a testamentary or special disability trust for Jody. Now, that's all well and said, but if there's a family provisions challenge, then all of that planning, all of those documents, etc., are all going to be subject to any family provisions claim. So there's a bit of an issue there. And alternatively, which I'm going to show you, is instead of doing that, it might be best to do a protector, and I'll show you what that looks like in terms of this. So we set up a family protection trust or a leading member trust. What we do there, I'll show you here. So what we do is we've got the home worth $2 million. He's got a watch worth 50, Porsche worth 250. His practice is worth 300, but that's in a trust, so we don't have to worry about that one. So what I can do is I can just take that out, but we'll assume that the practice is in his own name. So we've got $2.6 million of equity or net value that if we did a balance sheet for John, at the end of the day, taking out any liabilities, he's got $2.6 million or thereabouts, although I think there's a couple $100,000 owing on the, oh no, there's no mortgage on the property. So that's what we've got there. I haven't taken into account the investment properties. I'm going to look at that a little bit later on. So I'm just looking at the home at the moment. We looked at the SMSF, and we want to do everything out of that SMSF. Remember, it's going to be the pension. If we didn't want to go down that pension route, like, for example, John was too young, so we couldn't set up the pension, then what we could do is obviously, remember we had a look at SMSF Will, fold into an SMSF Death Benefits Trust for Sally and for Jody. Or alternatively, we could do a special disability trust, an SMSF special disability trust straight out of that SMSF for the purpose of looking after Jody, who is disabled. Here I've set up a Smith Family Protection Trust with a corporate trustee. You've heard me do this before. This is just a straight leading member trust. I've got John, then it goes to Max, and then Max's child, Kathy. Again, if it goes down that one. But remember, we've got Sally in there, so we need to work out, well, is Max going to be partaking of this or not? So that's pretty important. So what we can do there is gift the value of the property over to the Family Protection Trust, or the value of all this property, the 2.6 million, goes over there, and then it's lent back. So there's around about 10 documents to do, but you can do those easily in the protector. It's lent back a registered mortgage, because effectively it means that the property's 100% geared, so that now John owes the Smith Family Protection Trust $2 million, owes, in terms of the Porsche, $250,000, so on and so forth. So what that means there is that on John's death, a couple of things can happen. First off is that the trustee of the Smith Family Protection Trust, and again, it could be Max, it could be Sally. We have to work out who it's going to be, and that's pretty important. Again, that Max Sally position is really important. Given the fact they're from different marriages, I'd probably just keep this honestly to John, then Sally from that one, and keep it well away. So on death, what can happen there is that family home, instead of having a life interest, we don't need to do that. What we can do is that property title can be switched over to the Family Protection Trust, because most of you should be aware there's a call option that's attached to the protector. And that title would then, now the property would be in that Smith Family Protection Trust, and then there'd be a long-term peppercorn lease out to Sally for her life. Now, importantly from that one, if they then go and sell that property and want to buy another property, they want to expand, for example, Jody, and make it more appropriate for Jody, then there's no capital gains tax consequences on that surrender of that long-term peppercorn lease. So it's probably, we will be launching a whole set of documents around that. But again, it's a great little asset protection mechanism. So that's a way. Alternatively, if they don't want the property, then we can just simply sell it, put the proceeds over the Smith Family Protection Trust, and then Sarah and Jody would be looked at. So the more I look at this, Sarah, Sally and Jody we looked at, the more I look at this, I think there's just that. My intuition is that to put a blended family together in one of these trusts is a bit of a concern. The alternative we've got is, again, we can do this leading member trustee, which we've talked about. And this is the concept of the living trust. We've built the protector here, so that goes into here. But what we want to do is we've got our basic leading member trust. We want to turn it into a living trust. So it goes from here down to our bloodline beneficiaries, which include, if we wanted Max, obviously Sally, and also Jody. So we can have here a Max subtrust if we wanted to. So what happens on the death of both John and Sally? We can put monies into a subtrust here for Max, and a Jody subtrust if we want. Alternatively, we can put that out to a special disability trust for Jody if we want to do that. So these vehicles last forever and a day, particularly if you've chosen jurisdiction as being South Australia. Again, because it's in New South Wales, we want to make sure, again, from a bankruptcy, a litigation perspective, and also for this notional estate, that when we do the gift over, which we saw here, we've got to make sure that there's at least 2 or 3 years, generally it's 3 years on that gift over, that can be a clawback to the estate. But again, all of these sort of things, the best time to do it is now to get that clock running, which is really important. So you can start to see this leading member trust vehicle that we're building in with sub-trusts, which will be launched once we get our new site up and running, can last for multi-generations. Again, your skill is going to be able to put that all together. So now with the investment properties, and then I'll come and have a look at any questions. So again, there's probably a good chance that there's going to be a family provision challenged by Sarah, particularly it looks as though she's been left out of the estate altogether. So it looks as though Max and Jody, the disabled child, and Sally are being looked after. So John's trying to cut Sarah out of the will. Now, it's not that easy. She's obviously going to make a challenge on that one. If we put anything in the will, essentially any of the estate is in John's hands, obviously, Sarah's going to have a crack at it. The good thing about it, Jody will obviously need those sort of money. So her family provision, the provision that's need to be coming from John's estate to look after her, is quite significant compared to Sarah, who's obviously a successful doctor out in the regional estate. So when it comes down to a family provisions claim, there's no real law to worry about. Generally, unless someone challenges it, it's more about who's deserving of what. So it's forget about the will, who deserves what and looked after what. But again, I don't want to take that problem. If John wants to cut Sarah out, then we need to go through this process and move everything over into that family protection trust, and then go down this methodology. So we've got John, Sally, we've got the property potentially sitting in there, being the family home. It's out on a peppercorn lease to Sally. And in the meantime, have a sub-trust for John and also a sub-trust for Jody. But being mindful of the fact that Jody is also being looked after by way of an income stream, auto reversionary income stream. So that when we have a look at it, the auto reversionary can't be challenged from a family provisions claim. So that looks really good. The SMSF will, obviously that's something that I'm just looking at John at the moment. We're then going to have to go and have a look at in terms of Sally, what happens with her $1 million in super. We want to pay it out directly, so we can either do the reversionary, which is one option for John, or potentially a testamentary or disability trust that comes out of the trustee of the fund, doesn't go to the estate. The second one is we've then got to go and clean up his assets. So we use the protector there for the family home and also the investment properties as well. And then we end up developing quite a sophisticated living trust for that family, which would work well. So at the end of the day, we've got the executor sitting in there, and we need to do basic wills. He's going to need to do basic wills anyway. From that perspective, or even if it's not a bad idea, I mean, if he's cleared out all his estate, you just leave the will and let him go and test it, because there's nothing in there anyway, or go and do a really basic will for them. So that's the way that I would handle it in terms of, we looked at reversionary, I love. And remember, we're looking at it from a tax perspective, tax-free, because he's already taken it, sits outside the family provision. So that's a good one. With the family home, you know, you've got a particular issue around that family home. Actually, just with Jody, we'd also have to work out what's going to happen if Jody passes away in terms of that pension. So that could end up going from Jody, could go to Sally, or then could go to Max if they want, to the child. So you can effectively do that one. That's how far you can go down the track. You can go about 3 or 4 lineages down of that pension. So I love that. SMSF will is important, and out of that, the SMSF Death Benefits Trust, or the Testamentary Trust, which is really crucial as well. For the assets sitting outside in the estate in his own name, you've got problems, forget about that. Remember, we've got litigation problems, potentially with Sally as well. There's family law issues, a trustee in bankruptcy, and of course, the family provisions. So if he wants to leave out Sarah, the only way to do it is obviously put everything into that family protection trust and build that multi-generational one there. So we end up building that multi-generational trust. So there's quite a bit of work to do, but given where he's at the moment, it's absolutely crucial to do that. Now, you might have a client who's only got half those assets, but still got the same problems. Well, that's not going to be an issue, or someone who's got 10 times the amount of assets with the same problems. But we've got everything within that one case study. So as I said, after this session, I'll put this video up, I'll give the slides, I'll give my article on why SMSF wills rather than BDBNs. I'll give you the superannuation warehouse deed. So I want you to have a look at that. I'll put in the ClearDocs deed as well, have a review of that. I'll put in our deed as well as a sample, so have a review of that. And then I'll also put that SMSF will in there. Now, the SMSF will doesn't relate to the case. It's a separate case study we did, but just look at the wording. The more you can get involved in being able to read, understand, and apply, the stronger you're going to go up that competence level. If you can't, this is where most of you get frustrated. Unconscious incompetence is like, well, I'm just going to do a BDBN. I'm not going to read the deed. You might as well, who cares? I mean, there's absolutely no protection there. It's like a paper bag, it means nothing. Conscious incompetence is, well, if you haven't understood what I've said today or the process I've gone through today, then you need to get yourself up, probably do the accreditation course, the SMSF accreditation, get up to conscious competence. So those of you who are there, you need to be in a position of being able to read, understand, and apply the trustee, read, understand, and apply the BDBN or the SMSF Will, read, understand, and apply the reversionary pension, so you know what the laws are. These are the laws. Everything I've shown you in the deed is a law unto itself, because the SIS Act makes the governing rules, your deed, your pension documents, your BDBN, your SMSF Will, are actually treated as if it is an extension of the SIS Act. So that if anyone breaches the law, you've got an action to recover any losses or damages because of their breach. And if it's being done willfully for gain or reward, then effectively there's a potential 5-year jail sentence. So again, read these and understand it and know exactly what you're getting into, and don't breach the laws and the rules, which is absolutely crucial. So let's go and have a look at some questions. So I've looked at that one. Jenny, when using the protector for asset protection of the family home, should we also look at a long-term lease for the family? Jenny, at the stage, if I go back, and that's a really good question, and let's work through. So when I'm using the protector here, I've got the family home still stays in my name. So let's just go through and work out what to do. I'll just spend a couple of minutes on this before we'll close up. So John's got the deed title, and if I went to the land registry, I'll see John is on the title. Now, what I would see there is that John's on the title, but there would be a registered mortgage for $2 million to the Smith Family Protection Trust. So John's on the title, but he owns nothing inside that. If that house goes up in value, then remember we've got a call option deed. So John writes a call option to the Smith Family Protection Trust to acquire that property, $2 million. So if by the time he dies, it goes up to $3.5 million, then the value all sits inside there. So if he wants to, for example, Jenny, so let's go through, he decides to sell the property, it's getting too tough with Jody, and as a consequence of that, they're going to build a brand new property that's better off for a disabled person, NDIS or whatever. So he could sell the property. What would happen is on settlement, the proceeds go into that Smith Family Protection Trust. Now, he can go and put it in his own name, or alternatively, you buy the new house in here because that's where the cash is. Then you do that long-term peppercorn lease. And you'll see there, for those of you who did the course, if you go and have a look at our I think it's the bankruptcy and asset protection resources, there's an ATO ruling in those resources that deals with the fact that on disposal of that property in here, there won't be any capital gains tax. So that's a crucial one. So have a look at that private binding ruling. So that's the other one. On death, well, the issue there is that can be sold and transferred in, a new property can be. Alternatively, we can transfer that property from there into the trust for that specific purpose. Alternatively, we can look at transferring that property. We can put it over into Sally's name if we want as a capital distribution from that Smith Protection Trust. So there's a number of different things that happen on estate planning, but it's very easy. Likewise, if there was already a mortgage in there, the same thing, and then they sold it, some portion would go to the bank and some portion would go to that Family Protection Trust. So again, that asset doesn't reside in there. Anyway, that's enough for me. I'll send all this information out shortly, and we'll have a look next week. I know Michael's got a session. Again, make sure you keep up to date with all of our webinars. The more you come in, the more you learn how I apply it, the more you're going to be able to read, understand, and apply the law. You want to be consciously competent, and I know most of you are. Anyway, it's Grant Abbott, signing off.